Thanks, Chairman. Thanks to the panel for being here. I want to discuss a particular aspect of FOIA enforcement related to Exemption 5, the exemption for so-called pre-decisional materials. The logic of that exemption is that the chief executive is entitled to a robust debate among his or her subordinates in order to make the best quality of decisions. And those subordinates should not be playing to the galleries in the recommendations that they make in those debates. And therefore, the pre-decisional memoranda and conversations that lead to an agency decision should be protected. Is that a pretty fair description of what that's all about, Mr. Talebian?
Yes, the exemption protects pre-decisional and deliberative information, but of course we also apply the foreseeable harm.
So the concern that I have is that DOJ recently has tried to apply that exception, that exemption, in a case where there was no decision to be made. And when I say no decision to be made, I mean no formal agency decision to be made. I think there's a difference between a formal agency decision or a formal decision by the head of the agency and just the day-to-day decisions that people make all day long, the quotidian decisions about where you go next and what you eat for lunch and when you have your meetings and who's in the meeting. And everything in life is a decision. So if the exception is not going to swallow the rule, it has to connect to an actual agency decision that presumably has to be a formal agency decision. And what has happened in this case is that the Department of Justice, defending an internal report of its own that connected to no agency decision because there was a policy that drove the decision. So there was no decision to be made because the policy already existed and drove the outcome, was, I think, a very extreme view of the reach of pre-decisional. And I think once you untether Exemption 5 from an actual agency decision, it swallows the rule, and you will be enmeshed in enormous litigation, and there's no real discipline to decide, other than the agency's own prerogative, what it wants to disclose or doesn't want to disclose. So could you tell me, just for starters, what your role, Mr. Talebian, is in the establishment of the substantive rule at the department regarding the Exemption 5 and what is pre-decisional? Do you actually give advice about that, or are you more implementing advice that OLC and others have come up with? Let me just ask it that way.
Senator, my area of expertise is the FOIA, and I provide guidance on the FOIA to the department as well as agencies government-wide.
The case that I'm referring to is in litigation in the DC Circuit right now as Citizens for Responsibility and Ethics in Washington versus the United States Department of Justice. Did you advise the department in that matter? The substance was a report that was done related to the Mueller investigation, so-called. And the subject of the report was whether the President of the United States could be charged. And because the department had a policy that the President of the United States could not be charged with a criminal offense, period, end of story, it did not strike me or, frankly, courts as pre-decisional. Were you involved in advising the department with respect to that question?
Senator, that, as you mentioned, is a case that's currently pending before the DC Circuit Court of Appeals. As a matter of longstanding DOJ policy, I can't comment on ongoing litigation.
I'm not asking you to comment on litigation. I'm asking you to just ask whether you participated in that discussion.
I can't speak to the internal processes of the department, especially with ongoing litigation.
I can't speak to whether you, as the person charged with giving advice, actually gave advice in this matter?
Senator, I can tell you that, as part of processing of requests for the senior leadership offices, I was involved, but so are many others, and I cannot speak to ongoing litigation.
I don't ask you to speak to ongoing litigation. I'm a former Attorney General and U.S. Attorney. I'm well aware of that distinction, but I asked you a completely different question, which was, did you have a touch point on this in your role?
Yes, OIP was involved in that FOIA case.
Bingo. See, that was actually pretty easy once you got around to answering it. The reason I bring this up for the members is that in addition to the decision the department has made to allow itself to claim this exemption even when there's no actual decision, which allows the exemption to just run wild through the agencies, they've also taken the position that congressional requests for information are governed by FOIA. And so, as a member of Congress, if we are asking an agency for materials under the United States Constitution, exercising our right of oversight, we have to go through all the FOIA hoops. And so when the department is setting up its rules for how and when it responds to FOIA requests, how and when the executive branch responds to FOIA requests, they are also de facto setting up the rules for how we in Congress can get access to the information that is necessary to do our jobs. And I think we need to pay a lot more attention, not just to FOIA as an avenue for the public to hold agencies accountable, but to the question of FOIA as a screen behind which the executive branch can hide from congressional oversight. And I'll close by asking unanimous consent that my brief in that Crew case be made a matter of record in this committee hearing, which is joined by the chairman, I should add.
Without objection.
Very grateful to him, and also Senators Wyden and Blumenthal and Hirono and Warren and Booker for participating in that brief. Thank you.